I want you to pause for a second and really think about what it means when lawyers are dragged out of a federal courtroom by marshals. Not defendants, not witnesses. The lawyers themselves, I've spent decades watching institutions under stress, governments, markets, courts, and I can tell you this. When officers of the court lose control in front of a judge and a jury, something much deeper than a legal argument has broken. This wasn't just a bad day for Donald Trump's defense team. This was a system hitting a hard limit. Because the moment a lawyer stands up and makes a factual claim to a judge and that claim collapses in real time, the courtroom stops being a place of debate. It becomes a test of whether truth still matters more than loyalty. And when that test fails, force steps in quietly, relentlessly. In a moment, I'll show you why this explosion was not spontaneous, why it follows a pattern we've seen again and again, and why what happened in that courtroom is about far more than one trial. It's about the survival of professional standards in an age of political power. Stay with me, because once you see the mechanism behind this, you won't look at Trump's legal battles or the legal system itself the same way again. What most people miss is this. Courtrooms don't collapse because of emotion. They collapse because of incentives. On the surface, what you saw looks like rage, ego, desperation. But underneath, this moment was the logical outcome of a strategy that treats the legal system not as a place to test facts, but as a stage to dominate narratives. Trump's defense did not walk into that courtroom trying to win a narrow legal argument. They walked in trying to bend reality itself to substitute certainty with noise and evidence with accusation. And here's the critical point. That strategy can work in politics. It can even work in media, but it cannot survive inside a courtroom because courts operate on a fragile but non-negotiable rule. When facts collide, someone must yield. There is no alternative version once the record is clear. What you witnessed was the exact moment when that collision happened, when a carefully constructed story met a single document that refused to cooperate. And when the story cracked, the pressure didn't release. It exploded. To understand why this explosion was inevitable, we have to step back and look at how this defense was built, why it depended so heavily on credibility, and why one email was enough to bring the entire structure down. That context matters. And that's where we go next. To see why this moment mattered so much, you have to understand how Trump's legal defenses are built, not just in this case, but across years of litigation. The core argument is always the same. Nothing was intentional. Nothing was deliberate. Mistakes were made, but responsibility was diffused. That strategy depends entirely on one thing: trust. The court has to believe that lawyers are accurately describing what they reviewed, what they received, and what they advised. The moment that trust breaks, the defense loses its foundation. And for weeks, that trust held just barely. The defense presented itself as methodical, careful, professional. They challenged timelines. They pointed to ambiguities. They suggested confusion rather than obstruction. Legal analysts noted that this approach was creating space, not victory, but breathing room. But here's the structural weakness. When your defense is built on the claim that nothing exists, a single document can end everything. Because courts don't weigh vibes. They weigh records. Every email, every index number, every filing reference. These are not suggestions, they are anchors. And once an anchor is set, narratives cannot drift without snapping the chain. This is why prosecutors don't rush moments like this. They prepare them slowly. They let the defense commit. They wait for certainty. By the time that email appeared, the outcome was already constrained. What followed wasn't chaos. It was consequence. And that brings us to the first true rupture, the moment when argument turned into crisis. This is the point where everything stops being theoretical. Because when prosecutors say they have one more piece of evidence and the defense objects before seeing it, that's not confidence, that's fear recognizing itself. The email wasn't dramatic. It didn't need to be. Its power came from timing, dated squarely in the middle of negotiations. Already produced, already indexed, already referenced. And the moment it landed on the defense table, something snapped. Instead of caution, we saw escalation. Instead of verification, accusation. Instead of control, volume. This is where experienced lawyers usually pause. They ask for time. They reassess. They protect the record. That's how crises are contained. But that didn't happen. The claim was made on the record that the email never existed. Not overlooked, not misread, did not exist. That single sentence locked the courtroom into a binary choice. Either the prosecution committed fraud, or the defense had just lied to a federal judge. There was no third option. And when proof appeared, immediately production logs, filing references, their own motion, the room changed. You could feel it. Reporters described the tension as electric, but this wasn't drama. This was gravity reasserting itself. Here's the uncomfortable truth. At that moment, the case stopped being about Trump. It became about whether the court would allow reality to be shouted down. If you're still with me, this next part matters, because what followed was not just a meltdown, it was a professional point of no return. What happened next wasn't about anger. It was about incentives colliding with ethics. Every legal system rests on an assumption that rarely gets tested this directly. Lawyers may argue fiercely, but they do not fabricate reality. The moment that line is crossed, the system has only two choices: enforce boundaries or surrender credibility. Trump's legal orbit has tested this boundary repeatedly. The pattern is consistent. When evidence tightens, pressure shifts from facts to force, from persuasion to confrontation, from law to performance. Inside a courtroom, that strategy is radioactive because judges are not audiences. They are gatekeepers. Their authority doesn't come from popularity or narrative dominance. It comes from control of process. When that control is challenged, the response is not debate, it is enforcement. This is why accusations of fabricated evidence are uniquely dangerous. They don't just attack the prosecution, they attack the integrity of the court itself. That's why the judge asked a simple, devastating question. Was this a formal allegation? That question wasn't procedural. It was a lifeline. It gave the defense a chance to retreat, to recalibrate, to protect themselves. Instead, they advanced. Once that choice was made, once the accusation was confirmed, and the order to stop was ignored, the mechanism activated. Contempt, removal, silence, not as punishment, as necessity, because a courtroom that allows unfounded criminal accusations and defiance of direct orders stops being a court at all. And in the next moment, the system did what systems under existential threat always do. It shut the door. What happened next unfolded in seconds, but its impact will last for years. Once the judge issued a direct order, the situation entered a different phase. This was no longer argument, this was command. And in any functioning system, commands exist to prevent collapse. The refusal to comply changed everything. At that instant, the courtroom stopped being a place of persuasion and became a place of control. Marshals don't move because of drama. They move because the system has decided discussion is over. The second attorney standing up wasn't solidarity, it was contagion. In crises, systems don't evaluate intentions. They respond to behavior. And when disruption spreads, containment becomes the priority. Removal wasn't symbolic. It was surgical. 2 lawyers gone, a defense table hollowed out, a junior attorney frozen in place. And here's the part most people underestimate. Juries don't compartmentalize moments like this. They absorb them. They read behavior as signal, desperation, breakdown, loss of control. No argument made later can erase what was just witnessed. This is the second rupture, the one that can't be repaired with motions or appeals. Because credibility, once shattered in public, does not quietly reassemble itself. What follows now is the human cost of that collapse, not for lawyers or headlines, but for the people watching this system and wondering what it means for them. Now, step out of the courtroom for a moment and put yourself inside the system as a citizen. Because if you're watching this, you're not just witnessing a legal meltdown, you're asking a quieter, more personal question. What happens to the rules when powerful people decide they don't apply? For most people, the law is supposed to be boring, predictable, reliable. It's the thing you count on when you sign a contract, follow a regulation, or trust that disputes will be settled by evidence, not volume. So when you see lawyers, trained professionals shouting at judges, refusing orders, accusing prosecutors without proof, something deeper cracks. It shakes confidence. You start wondering, if this is how the system behaves under pressure at the top, what happens at the bottom? And that's why moments like this matter to you. Because the rule of law doesn't erode all at once. It erodes when norms are treated as optional, when ethics are reframed as obstacles, when loyalty is rewarded more than truth. If you care about living in a society where facts still matter, where courts are not stages and justice is not a performance, then this isn't someone else's problem. It's yours. And if this analysis is helping you see that connection, pause for a second, share it, talk about it. Because systems don't defend themselves, people do. Next, we need to widen the lens, because what happened in that courtroom doesn't stop at national borders. The ripple effects are already moving outward. When moments like this happen in the courtroom of a global power, the world pays attention. Not because of the personalities involved, but because legal systems are signals. They tell allies, rivals, and markets whether rules still constrain power or whether power has begun to escape them. The United States has long positioned itself as a benchmark for institutional stability. Courts are central to that claim. When courtroom norms visibly fracture, the damage isn't contained domestically. It radiates outward. Authoritarian governments watch closely. So do fragile democracies. They look for confirmation that legal constraints are optional, that institutions bend under enough pressure. Every public breakdown becomes ammunition in a much larger narrative. That rule of law is a myth powerful countries preach but don't always practice. At the same time, allies rely on predictable legal systems to manage trade, security, and cooperation. Trust is not built on speeches, it's built on process. When that process looks chaotic, uncertainty spreads. This is how isolated incidents become systemic risk. Because once people believe courts are arenas rather than arbiters, every dispute escalates. Every loss is contested. Every decision is suspect. The system slows, hardens, and eventually loses legitimacy. What you saw wasn't just disruption, it was a stress test, one that revealed how thin the margin really is. And now we reach the hardest question of all. Where does this trajectory lead? Because systems under stress don't drift randomly. They converge toward outcomes. There are only a few possible futures from here. From here, the system doesn't have infinite paths. Under sustained pressure, complex institutions narrow toward a few outcomes. The first is the best-case scenario. The court responds firmly but cleanly, misconduct is addressed, standards are reinforced, future attorneys see clear boundaries, fight hard, but don't cross reality. In this outcome, the system absorbs the shock and emerges more disciplined, less tolerant of theatrics, more anchored to evidence. The second is the middle path, the most common and the most dangerous. Consequences are partial. Language is strong, enforcement is uneven, the lesson becomes ambiguous, some lawyers pull back, others test the edge again. Norms erode slowly, not through collapse, but through fatigue. The system still functions, but trust thins. Then there's the worst-case scenario. If misconduct is reframed as heroism, if defiance is rewarded politically, and if accountability is delayed or diluted, the signal becomes catastrophic. Courts become stages. Truth becomes negotiable. And every future case escalates faster, louder, and more destabilizing than the last. Here's the hard truth. Systems don't choose their futures by rhetoric. They choose by response. What is enforced becomes the rule. What is tolerated becomes precedent. This moment will be studied not because of who was involved, but because it revealed a choice point, one where restraint, accountability, and institutional courage either reassert themselves or recede. And that brings us to the final question, the one that decides whether this was just another crisis or a turning point. Here's the insight that cuts through all the noise. What failed in that courtroom wasn't just a defense team. It was the illusion that power can permanently overpower process. Legal systems don't survive because people behave well. They survive because consequences exist when people don't. When lawyers choose loyalty over truth, when they treat evidence as optional and authority as negotiable, the system is forced to respond not emotionally, not politically, but mechanically. Remove the disruption, restore control, preserve function. That's what you witnessed. And this is why the outcome of this moment matters far beyond Donald Trump. It answers a question every democracy eventually faces. Are the rules real or are they conditional? If they are real, enforcement follows even when it's uncomfortable, even when it's public, even when it involves powerful figures. If they are conditional, then every future courtroom becomes a battleground, not a forum for truth. The next phase of this story won't be loud. It will be procedural. Quiet decisions, professional consequences, institutional memory. Those are the moments that actually decide history. If you want to understand where this goes next, how this reshapes Trump's remaining cases, the legal profession, and the boundaries of acceptable defense strategy, stay engaged. Share this analysis. Keep watching. Because systems don't collapse in a single explosion. They reveal themselves in moments like this. And once you see that, you can't unsee it.